নমস্কার, রণজিৎ আপনাদের সবাইকে স্বাগত। আশা করি সবাই ভালো আছেন। বিকাশবাবু কিভাবে এই রাজ্য সরকারকে একেবারে বেআব্রু তো অনেক দিন আগে থেকেই করছেন, কিন্তু এই 32,000-এর চাকরি, সুপারনিউমারি পোস্ট, এগুলো নিয়ে যে আবার রাজ্য সরকার 2026-এর নির্বাচনের আগে বড় বিপদে পড়তে চলেছেন, সেটা এই সওয়াল জবাবে শুনুন। প্রথম পর্ব শুনিয়েছি, এটা শুনলে আরও দেখবেন যে কি চমক আসছে। আসলে এই বিকাশবাবুর সওয়াল জবাব শুনতে এজলাসে যে পরিমাণ ভিড় হয়, এই প্রজন্মের যারা আইনজীবীর ছাত্র তাদের কাছে এটা শিক্ষণীয় সেই হিসাবেও দেখানো, একই সাথে রাজ্য সরকারের যে নগ্ন রূপ সেটাকেও তুলে ধরা এই প্রতিবেদনের উদ্দেশ্য। দেখুন, একটু ভালো লাগলে লাইক শেয়ার করে দেবেন।
22, the last 3 lines. I am not reading the entire thing. Your petitioner states that the respondents and each of them acted illegally, arbitrarily, and unconstitutionally in appointing some candidates who did not even sat for TET 2014. Serious allegation. Now, from the cans which were admitted by the court, I have prepared a list only to show that how many rank jumping was there. I shall place that. I have given them the copy also. In the background of this pleading of the writ petition, now kindly takes up the affidavit filed by the board. That is in Millard, volume 2, at page 359. Now, Millard, I would make this submission, probably it might be repetition, that an authority or institution always go by institutional memory. They do not go by individual's memory. And when an authority affirms an affidavit denying the responsibility of the previous period, it seems he admits, my lord, that there were some irregularities. I just place the language. I say that, paragraph 3, I assumed office at the President of West Bengal Board on 24th of August 2022. I was not the President of the board when 2016 recruitment process was instituted and subsequently completed. The court did not want to know that whether you are responsible, but the institution was responsible. Then from records available in my office, it is evident that in the 2016 recruitment process, marks were given by the selectors, both in interview as also in aptitude test to the candidates. I would appeal to your lordship to read between the lines. Based on such records, I submit with utmost respect that the coherence which can be drawn thus far from such grant of marks by the selectors for aptitude test to candidates, thus far thereafter within the bracket, from such grant of marks by the selectors for aptitude test, is that such aptitude test was held. He does not positively say that from records, it is apparent that the aptitude, he wants to draw an inference on the basis of what? Since marks were allotted. Paragraph 6, he now says what steps has he taken in 2022 recruitment process. And it's interesting, my lord, would please to read. In the 2022 recruitment process, which commenced after I assumed office, the board has taken various steps which are first of its kind. Therefore, it's an admission that these measures which would have protected the selection to maintain its fairness was not there. The interview and aptitude test of a candidate for the 2022 recruitment process is being taken, but I am not concerned with 2022. He was supposed to answer from records about 2016. Therefore, without this affidavit, in my humble submission, Millard clearly admits. Then kindly come to 363, another affidavit by the President. Here, Millard, he describes from several authorities what aptitude test mean. Kindly not troubling my lord with this huge quotation from great authorities. I am not at all interested. Kindly come to paragraph 12. The second direction contained in the order dated 24th of January 2023, passed by this honorable court, directs me to submit the list of interviewers at page 375.
4th January order.
Yes. 24th January order, Malat, he was directed to file affidavit explaining the situation. The page 423, I'm thankful to my friends. The order says, in course of hearing, a serious allegation was made by the petitioners that in the selection process of 2016, the stage of interview and aptitude test came, only interview was taken and there was no aptitude test. Though in aptitude test, there are 5 marks. As a large number of petitioners were present in the courtroom, I decided to exercise my power under Section 165. Oath to 7 of such candidates being so and so, so and so, this is the order.
Yes.
Yes.
Now you are showing us para 12.
Yes. The second direction contained in the order dated so and so, Pathways Court directs me to submit the list of interviewers who interviewed, took the aptitude test, so and so. I say that 2016 recruitment process was a district-wise selection. 2022 the center. Now they say 2016 was district-wise selection based on the opted districts of the applicant and candidate. The interview Vivabosi aptitude test was conducted at centers under the respective district primary school councils. And there is as such no distinctive record which was kept and maintained in such recruitment process, wherefrom it can be ascertained as to which interviewers took Vivabosi aptitude test of a given candidate at a given center in a particular room. In 2016 recruitment rules, no method was suggested. This is the difference. Are required to be maintained by the examining body. However, a full and complete list of interviewers available with the board. Only board maintains at the center the list of the interviewers. And they don't have any record to show at all the interview was taken or not. That is admission. On the face of such a serious allegation, when the court directs to file an affidavit, not an authority who is entrusted by law to hold the examination fairly in compliance of Article 1416, files this affidavit. Now, here, my lord will not find anything about the allegations made in the petition. Maybe that this was not directed to be do so. Then kindly come to another affidavit at page 378 by Dr. Partha Karmakar. Here he deals in detail. Now that he meticulously takes the point, it's not maintainable, this and that. Because the state authorities, when takes the point of maintainability, that should really raise doubt in the minds of the court about their transparency and impartiality. Kindly turn to page 389, paragraph 9 of the, sorry, before that, I missed one paragraph. Paragraph 8. Their whole attempt is to see that the petitions are knocked out on the ground of maintainability. These issues have been considered by the court. I shall come to later. They say in paragraph 8, that Rule 6.3 is applicable to all applicants who applied in 2060 recruitment process. There is no challenge in the said petition to Rule 6.3 of the 2060 recruitment rules. But why should I challenge? I rely on this. I rely to show that 6.3 has been blatantly violated. I shall test that. Then again, paragraph 9. But if I use this term, kindly excuse me if it is not suitable. But it's a fantastic defense, paragraph 9. I say that applicable recruitment rules of 2016 made in exercise of delegated legislative power by the School Education Department, Government of West Bengal, never mandated the answering respondents to publish in public domain the panel, merit list, category-wise merit list, breakup of marks, rank of candidates as contained in writ petition. Now, this is an admission that they did not do so. They say that we have not been done. Delegated legislation does not provide us to do so. Transparency, go ahead. Article 14, 16, go ahead. And then further, the recruitment rules 2016 has not been challenged in the said petition. Such being the position, the answering respondents cannot be faulted not to have caused publication of the above in public domain. It's a clear admission they did not publish. However, in terms of the directions passed by the Honorable Court, the answering respondents did publish breakup of marks whom for candidates who were recommended from the 2016 recruitment process.
2022.